Guys, Advocate Mushololo to recuse herself from General Khumalo's bail condition application matter. Why? Do you know? If you know, let me know on the comment section. I don't understand Advocate Defo. He went to court to go and block the bail condition application of General Khumalo. And then when he was given the platform to speak, he went overboard, and he also demanded that Advocate Mushololo should recuse herself from representing General Khumalo. I don't understand. What is the reason for that? What can be the reason for that? I wonder. If you know, let me know on the comment section. Unfortunately, the magistrate did not give him more time to elaborate, and then he was told to sit down. So, yeah, Advocate Defo, what is this that you are doing? Let me know on the comment section, guys. Do you think Advocate Defo could have maybe filed a new case for General Khumalo, because he was complaining about being intimidated and arrested and harassed and all those things that was done by General Khumalo and his crew? Do you think he could have maybe filed a new case with the police, the case that will be investigated and be ventilated in court, instead of trying to hijack now General Khumalo's bail condition application case? What do you think? Let me know on the comment section, guys. Do not forget to subscribe, like, and share. You are going to now listen to the arguments between the state and Advocate Mushololo. The state is going to apply to the High Court because the magistrate that gave General Khumalo and his co-accused bail recused himself from the case, from this matter, because of him being implicated in the Madlanga Commission of Inquiry. So the state is not okay with that, and they said they are going to apply to the High Court that the magistrate, Mr. Mahlangu, should come back to preside over this case. So we don't know how it will go. And then this matter now was postponed to the 6th of November for argument, and then the court will decide thereafter. But in the meantime, we will also be waiting to hear from the High Court, because the state is lodging an application with the High Court. They want Magistrate Mahlangu back to the case, to preside over this case. I don't know why. The actually main matter which is before this court, in brief, the accused 1, 3, and 4 in the main case are applicants in this matter in terms of section 63 to amend a bail condition which was set by your brother Mr. Mahlangu. The proceedings started on 22nd of August 2015 and postponed to 2 other dates, and yesterday on the 14th of October, Mr. Mahlangu then accused himself from the proceedings on the basis of the events that are happening at both the Madlanga Commission and the parliamentary portfolio proceedings. He then informed us yesterday in court of his reasons for accusing himself, and that's how then the matter was then reallocated to you as a new presiding officer in the case. We have since, as the state's team, looked into the decision of Mr. Mahlangu to recuse himself, and we are of the respectful submission that it ought not to have happened the way it did, and that it's not in compliance with Section 22 of the Superior Courts Act, and therefore, on those bases, we intend to make
the High Court to have the decision of Mr. Mahlangu recusing himself from these proceedings reviewed and set aside. We have already compiled our papers, Your Worship. This morning, the investigating officer just deposed an affidavit. We are on our way to the High Court to say we have a copy that we can show to the court as proof of what we're going to file later today. And as a result, we are not in a position to start with a new Section 63 application today, since we are reviewing the decision of Mr. Mahlangu. It is not going to set the interest of justice, Your Worship, that while we are reviewing the decision of the presiding officer, that we start with the process again, because there's going to be two parallel processes running. I just want to I have a copy for Mr. Mshololo, Your Worship. These are documents that we got to send this morning to the High Court. It's a notice of motion compiled by us in the state. And in support of that notice of motion, we've attached the affidavit of the investigating officer, Mr. Brian Fadayachi, who's with me today here in court. It's also attached to the application.
So that the application in terms of Section 63 subsection 1 of the Criminal Procedure Act that we are bringing before this honorable court for the amendment of bail conditions be able to proceed before another condition. Be able to proceed before another judicial officer. Now, Your Worship, the state makes the submissions that they intend to review such an application, such a ruling by the magistrate, which is a recusal. And there are no basis placed before this honorable court showing the prospects of success in that review, as the state is reviewing the magistrate when the magistrate himself has recused himself. The requirements for the review, the basis and the grounds for the review have not been placed before this honorable court. I have not been served, we have not been served. I'm sitting in front, next to me, my instructing attorney, Mr. One. We have not received, we have not been served any papers for the application for any intended review. My submission, Your Worship, is that these proceedings, the application in terms of Section 63, cannot be prohibited or cannot be prevented, cannot be disallowed to proceed because of the wishes of the other party. If the state intends to bring such a review application, they have a right to do so, they have a right to file their application, we will be served. And also, Your Worship, the fact that the other party intends to review or intends to appeal does not mean never happen in our law to grant someone to proceed with the review because we have no papers that have been filed in court. I would ask that the very condition that you are asking that it be amended pending the finalization of the review that the state intends to file. Secondly, my lord, this is a great application. The ruling for the magistrate is not even appealable. And it does not necessarily mean that the rate on refusal. That does not necessarily mean that the proceedings for the bail application, for the amendment of bail application should be stopped. There is nothing, there is no rule preventing, there's no provision preventing this honorable court from hearing the application for the amendment of bail conditions as it is set to proceed today. Until that decision, because even that decision, even if it can be granted in the High Court, we are making submissions on speculations which were not allowed to address his lordship on speculation of the review of which we don't even have the text of such a review. It's my humble submission, Your Lordship, that this matter should proceed before the honorable court today to allow the applicants to go back to work pending the finalization of the review by the state as the court proceeds.
Submitted that if I grant the state that permission, then I must relax the bail conditions. The relaxation of the bail conditions is the bone of contention in this case. I cannot make a ruling before I've heard the prosecution and the defense on the issue. In the circumstances, I will allow the prosecution to file their review. The main issue cannot be dealt with today until we have the outcome of the review.
There was a date, 6th November was the date to which the main case has been postponed to. May this the accused also then the matter be postponed to the same day. In the interim, we'll be filing our documents before the end of business today. Proof of service of our notice that the High Court will then be provided to what's the legal representation. The 6th of November. The accused are on bail of 10,000 rand each. To make this and that the matter be remanded back to court 16th of November.
Yes, the matter is adjourned until the 6th of November.
Court 16 for outcome of the review application, be in court 8:30.